Another issue that's often encountered in workplace investigations is whether the employer may suspend an employee suspected of wrongdoing during the investigation. Now, you would think that that would be something that would not necessarily be always allowed, but our courts typically have taken the view that the employer will have that right of suspension in what is called an administrative suspension. That is, no allegation is being made that the employee is being disciplined, that the employee is simply told, we want you to cooperate in the investigation and don't come into work until we've completed the investigation. And generally speaking, the courts have allowed that as an implied term of the employment relationship, provided a few other conditions are met, such as, number one, the employer is acting in good faith, that is, has reason to believe there's a legitimate complaint and wants to investigate it, and there's legitimate business purpose behind it. Number two, the suspension is for a short period of time. Now, obviously, when the investigation starts, nobody knows how long it's going to take. So that's a big issue. And the employee should be told that it's going to be for 1 week or 2 weeks or whatever, but it has to be for a short time period. Also, thirdly, the suspension has to be given with pay. And fourthly, it has to be generally shown that this suspension will have a minimal impact upon the employee in question. And if all those conditions are met, then chances are the court is going to give the employer that right as an implied term of the employment relationship. Now, if you're the employee, it's not going to be a happy day for you, because if you're sitting on the sidelines, everybody's going to think something's wrong and something happened. So the employer should take care in telling any staff members, any other relevant staff members, that this is not a sign of any wrongdoing. It's simply an attempt to take a good faith attempt to investigate the circumstance involved. Now, if there is such an implied right found, then the employer has to show some other issues as well. It has to show that there's a sufficient connection between the nature of the alleged offensive conduct and the employment held by the individual. It must show there's reasonable grounds to believe the status quo, even temporarily, may be prejudicial to the employer's interest. And also, if there are immediate and significant adverse effects, the employer has to show that it cannot be offset by a temporary assignment to another position. So that's the general rule. Obviously, some of those are vague, but that's the sort of the general landmark of what a court will consider. On the other hand, if the suspension is disciplinary, then the employer will not have that right. This all presumes that there's no employment contract in place. Sometimes there may be. Sometimes an employment contract may exist, and it may give the employer this right to suspend in a manner different from what I've described. What I've described is simply the administrative implied term of the employment relationship to effect this administrative suspension. So sometimes an employment contract may change the terms of this, and obviously that will depend upon the wording of the contract. So if you're the employee or the employer, you should know your rights and know what can and can't be done in this circumstance. As I mentioned in the previous video, if the investigation is not conducted fairly, there's huge potential for aggravated and punitive damage awards.